Taigi, tęsėme savo seminarą
Ladies and
tema
gentlemen, we
duomenų
continue
apsauga
our
ir
seminar on
kviečiame
data protection
profesorių
and we
pratęsti
invite
savo
Professor
pranešimą.
Štidilis to continue with his
Thank you.
presentation.
I will share my screen. So we talked about basic principles of risk assessment, and we can move further. I will shorten some slides in order not to be far behind of time. So data mapping, when we talk about data mapping, without data mapping, data inventory, you won't know exactly which system process personal data, where it comes from, and to whom is provided, and etc. Therefore, security measures in such case may be difficult to determine precisely. So we have to have all answers, why personal data is processed, what personal data, for what purposes, what are legal grounds, how personal data are processed, for how long, etc. And now we have security risk management cycle, risk management for personal data, and we can see that we should begin from defining the context of personal data processing. It means data mapping. After that, we identify relevant security threats. Of course, we should calculate risk according to mentioned methodology. We should select appropriate measures and implement certain measures. And it's very important to mention that security risks must be assessed for every information system or for every purpose of processing of personal data. And after that, specific security measures are identified. And here we have organizational security measures and technical security measures. So security measures basically can be divided into two categories. And we can see organizational security measures and types of such measures. For example, we should have security policy and procedures. We should have roles and responsibilities regarding access to personal data, including access control policy. We should have control. We should control data processors. We should have training, annual training, and etc. Of course, confidentiality of personnel, it's very important. All employees should sign agreements, for example, regarding confidentiality of personal data, etc. And technical measures are related with more technical issues. For example, if we have access from mobile portable devices to personal data, we should have technical security measures regarding mobile devices. Of course, physical security is very important. At the end, I will provide some simple measures. Let's call it like security hygiene, and some practical issues of organizational security measures. So let's discuss about practical examples, and I think it will be much more clear. For example, weak control of processors, lack of control of processors, or there is no agreements with data processors, failure to conduct cybersecurity training. Usually in the training material, we can see, for example, what are the basic principles, or what are the data breach procedure, etc., etc. But it's very important to include material about personal data security, what we should do or not to do, how to implement, how to implement, and how to secure our organization and personal data. Another issue: no rules on password usage or no documented password policy. It's weakness in backup or business continuity policies. For example, if we have incident with ransomware, for example, when data is encrypted and we do not have any backups, so we are in trouble in this case. Weakness in security management policy of IT providers, no mobile policy, mobile devices, policy, lack of emergency personal data recovery procedures, unencrypted laptops, absence of logs in the server, and etc., etc. So there are a lot of issues with organizational security measures. And some practical issues with technical measures. Of course, usually technical people are responsible for those measures, but let's see to the list. For example, personal data is not deleted after the term after the term for processing ends. Personal data, for example, drawbacks related to access control, almost no access control, or administrator access is not fixed. Employees changing positions may have old access to the systems. No user inventory is performed, and needs to know principle, access principle is not implemented, password not changed periodically or changed too infrequently, and etc., etc. So there are, of course, we should look to security measures very seriously, because according to European practice, quite a lot of fines are related with non-implementation of security measures. And we can see also automatic tool provided by ENISA, which helps us to conduct security risk evaluation regarding security measures, and to detect what security measures are important and should be implemented. So instead of mechanical work, we can use this automatic tool, and these are at the left. These are we can start from data inventory. After that, we identify risks, indicate impact, and etc., etc. So at the end, we can export the file with the list of recommended security measures, and to have evidence of compliance according to the GDPR. Of course, this automatic tool can be used in case of data protection impact assessments, when we want to evaluate personal data security side. So this is very useful automatic tool, and I recommend to use in practice. And now we have personal data breaches, several slides on personal data breaches. And for example, the biggest data breach in Lithuania so far has occurred with the car sharing company, when data from over 100,000 users has been leaked, and the company was fined by the largest fine so far in Lithuania, 110,000 euros. So it's very important to understand what security breach is and what to do in the event of security breach and how to prevent such breach. We can see definition. What is treated as a security breach? It means a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored, or otherwise processed. It's also related with mentioned C8 triads. And possible consequences can vary from physical, material, non-material damage to data subjects, for example, loss of control over their personal data. As I said, example could be the personal data sent to person which is not in the list of notary partners, etc. Financial loss, unauthorized damage to reputation, etc., etc. So a lot of possible consequences could be in case of data breach. And data breach can include access by unauthorized third party, sending, as I said, personal data to incorrect recipient, loss of availability of personal data. And example could be infection by ransomware, so-called ransomware. It's a malicious software which encrypts the controller's data until ransom is paid. This is very usual risk in Lithuania as well. And this could lead to a temporary loss of availability if the data can't be restored from backup. However, a network intrusion still occurred, and notification could be required if the incident is qualified as confidentiality breach. Please remember, as I said, one of the CIA triad components breach could be treated as security breach. So we have confidentiality, availability, and so incident may be qualified as confidentiality breach. And this presents risks to rights and freedoms of data subjects. In this case, breach should be reported to data protection inspectorate, and in some cases to data subjects. This is questionnaire who can help us to understand essential aspects you need to ensure in the preparation stage. For example, we know how to recognize personal data breach. Yes, we understand what personal breach isn't only a loss or theft of personal data. We have prepared response plan in the case of personal data breach. We have allocated responsibility for managing data breaches. Yes, and our staff know how to escalate a security incident. So every employee must be aware that he or she must report the breach to his or her supervisor or responsible person. This is a very important rule. And as I said, breaches could be connected with one of CIA triad elements. Responding to personal data breach, also the self-questionnaire. So we have in place process to assess the likely risks to individuals. We have process to inform affected individuals. So there should be clear rules, clear processes to what to do if data breach occurs. And the term to inform, for example, Lithuania State Data Protection Inspectorate is only 72 hours. If data breach occurs on Thursday evening, yes, so we have only 72 hours to inform supervisory authority about data breach. And of course, we should document all data breaches, even they don't need to be reported to supervisory authority. Here we can see recommendations from ENISA how to evaluate. So in practice, it's often asked how to assess the risk to data subject and how to decide whether breach should be reported to supervisory authority or whether breach should be reported to data subject or data subjects. And here is a methodology that can be used. Let's see an example. As we can see, the loss of the same personal data can be treated very differently according to context. For example, loss of names and telephone numbers can be treated very differently. First case, loss of, let's say, consumer data of supermarket. Yes, and in the worst scenario, case number 4, list includes names of people working for Secret Service. So according to context, data breach can be evaluated very differently. And statistics, some statistics from Lithuania this time. So 39% of personal security breach occurred due to human error. It's a statistics from 2001. What can we say? So the weakest part in ensuring the security of personal data is often the individual, not the systems, but individual. So that's why we are talking about social engineering, attacks, and etc. In practice, therefore, a number of measures need to be put in place to ensure that employees understand and acquire right skills regarding protection of personal data. For example, recommendations for employees on safe behavior in electronic working place, staff training, including the exam. It's very, very important thing to evaluate knowledge, yes, or after the training. Of course, internal communication before, at the time of the data breach and after the data breach, for example, lessons learned. And of course, we can speak about checks on how procedures work in practice. Without an inspection or checks, you can't find out if the staff has actually understands the material and if acquired the required skills in practice. So inspections or checks how it works in practice are very important. For example, we can send some misleading emails to our employees and check how they react to those emails. And some recommendations on safe behavior in electronic workplace. Security of personal data, to my opinion, starts from simple things. In practice, there are basic safety requirements, also known as safety hygiene. So, for example, create a strong password and update it regularly. What was the problem with this biggest data leak case in Lithuania with car sharing company? Yes, data was leaked, including passwords. But what was the main problem with that? So the passwords of data subjects was very simple, and they used the same password for several cases. So the data leak, when data was became public, yes, those passwords were used by criminals in other information systems, because data subject usually uses the same passwords in several systems in electronic shop, in banking system, etc., etc. Do not open emails on unknown origin letters or references. Please show those emails to IT person. Do not allow unauthorized personnel to access documents, databases, information system, or devices interested to you. Keep documents, including personal data in workplace, only in places inaccessible to outsiders. Do not leave unauthorized persons alone in your workplace. Use only licensed software. Do not install any non-operational programs in your main computers, and etc., etc. So these requirements, it's like a safety hygiene, and we should start from such simple things, simple steps in practice. And now we have several tasks. Of course, our time is limited, so maybe we should start from the first task. And I will read, and I will let's say I will provide the right answers. Why one or another answer is correct or not correct. And the task is actions in case of personal data breach according to the GDPR in case of personal data breach. The first option, the controller and the processor shall without undue delay and where feasible, not later than in 72 hours after having become aware of a breach, notify it to supervisory authority unless the personal data breach is unlikely to result in a high risk to freedoms of natural persons. Another option, the processor shall notify the controller without undue delay after becoming aware of personal data breach. The third option, the controller and the processor shall without undue delay and where feasible, not later than 72 hours, communicate the personal data breach to the data subject. Another option, the controller without undue delay, where feasible, not later than 72 hours after having become aware of a breach, notify it to the supervisory authority, unless the personal data breach is unlikely to result in high risk to data subjects. And the last, none of the above the answers are right answer. So in case of personal data breach, the controller and the processor have separate roles. The controller is responsible for notifying data subjects and or supervisory authority. And the processor must inform the controller about the breach, only to inform controller about the breach. And that's all. But of course, after that, to help, to investigate the breach, and etc., etc. But the data processor alone is not authorized to take any other actions with data subjects or supervisory authority. Therefore, the correct answers are two, the second and the fourth one. The second one, the processor shall notify controller without undue delay after becoming aware of personal data breach. And the fourth one, the controller should take some measures informing supervisory authority and, if needed, also data subject in case of there are high risk to data subject rights. So right answers are and now the task I know you have this task printed. Theft in notary's office, and the fabula is computers of a notary and his office staff were stolen, which stored personal data, by the way. So the data on the disks of stolen computers has been encrypted, password protected, and the data is backed up. So the question is, what steps must a notary take in the case of theft? And there are four options. So theft in notary office, the computers were encrypted and personal data were backed. What steps the notary should take in case of this data breach? So please read the answers, and you shall indicate the right answer. Just indicate the right answer. So please discuss among your colleagues and please give me the right answer.
Jei dalyviai salėje man neprieštarautų ir pritartų, tai siūlyčiau, jog teisingi atsakymai
Well, if
yra
you are not
pirmasis
against,
ir
then
trečiasis.
I'd suggest
O
that the correct
antrasis ir
answers are the
ketvirtasis
first
atsakymai yra
one and the third
neteisingi vien
one,
tik dėl to,
and
jog
number 2
abiejose
and number 4 are
atsakymuose yra
incorrect
nurodyta, jog
because it is
apie
indicated in
įvykį
both answers
nereiktų pranešti
that there is no
asmens duomenų apsaugos
necessity to
inspekcijai.
inform
Tai
the Data
galbūt mūsų
Protection
būtų toks
Authority.
atsakymas,
Well, this is
koks būtų
our
jūsų vertinimas,
answer.
profesoriau.
Professor, what do you think about it?
So let's start from encryption process. So strong encryption practically protects data from unauthorized access. So data subjects are not considered to be at risk in this case. When we have encrypted computers, there is no risk to data subject. Of course, I am talking about strong encryption. Accordingly, neither the supervisor authority nor the data subjects need to be notified. However, the police, of course, must be informed about suspected crime, and therefore the correct answer should be the fourth answer. But let's discuss. I know we almost have no time, but let's discuss the second task.
Trečias ir ketvirtas atsakymas. Ar gerai jūs suprantate?
I will read only the fable. So the notary leaves his car at the supermarket, and a work computer with personal data remains on the back seat of the car. When a window is broken, a thief steals a computer. Also, the disk of the stolen computer was not encrypted, but the computer was protected by biometrical technology. It means that computer could be activated only with fingerprint of the notary, for example. As you know, biometrics in the case of fingerprint are unique, and it's practically impossible to lose this data like a password. And the question is, what actions must a notary take in the event of that computer theft? So no encryption, but protection using biometrical technology. In this case, after stealing the computer, the fingerprint reader that is in the computer can be mechanically disconnected from the computer and personal data can be accessed if it's not additionally protected, for example, encrypted. So in this case, therefore, the correct answer is the third answer. Information of the police also must inform supervisory authority and data subject, and if there is high risk to data subject. So we can think that biometrical technology is very safe, but in practice, in this case, when the fingerprint reader can be mechanically disconnected, so it's not a safe way to protect personal data. So in case of theft, the notary should inform supervisory authority as well as police. I don't know if is everything clear about this task, and if I explained.
Yes, thank you very much for your comment.
And I think we have 5 p.m. Lithuanian time, and then it should be also YouTube material about personal data breaches from colleagues from Latvia, if I correct.
Yes, Professor, you are absolutely right. Thank you very much for your presentation. And now I would like everyone to invite to watch the video material on data protection.
Thank you all for your attention.
Le responsable du traitement et son sous-traitant sont tenus de coopérer avec l'autorité de protection des données. La coopération a lieu à la demande de l'autorité de protection des données, mais peut également intervenir de manière proactive. Par exemple, dans le cadre de la notification des violations de données à caractère personnel, plus communément appelées les fuites de données.
Une violation de données à caractère personnel consiste en toute atteinte aux données entraînant de manière accidentelle ou illicite la destruction, la perte, l'altération, la divulgation non autorisée de telles données ou l'accès non autorisé à celles-ci. Les personnes concernées sont, au niveau d'une étude notarielle, les parties aux actes authentiques ou encore les collaborateurs de l'étude. On parle ici de fuites de données relatives aux informations salariales, par exemple. Bien que le risque zéro n'existe pas, le notaire doit mettre en œuvre les mesures techniques et organisationnelles appropriées afin de garantir un niveau de sécurité approprié et éviter de la sorte la survenance d'une violation de données. Pour commencer, le notaire va rédiger un registre des traitements. Ce registre décrit les finalités poursuivies, le détail des catégories de données à caractère personnel, la liste des destinataires de données, etc. Ce registre va surtout être très intéressant et utile car il permet au responsable du traitement, donc le notaire, ou à son délégué à la protection des données, d'identifier les traitements qui pourraient impliquer des risques pour les droits et libertés des personnes concernées. Ainsi, les mesures appropriées à mettre en place afin de sécuriser les traitements de données sont bien plus facilement identifiables. Par exemple, le notaire s'assurera ou fera assurer par son fournisseur informatique que l'accès à Internet est sécurisé, que les logiciels antivirus des PC portables sont régulièrement mis à jour, que le système impose l'utilisation de mots de passe adéquats ou encore qu'une mise en veille automatique se déclenche automatiquement après un certain temps.
L'obligation de notification impose au notaire d'informer l'autorité de protection des données et les personnes concernées des cas de violation de données personnelles, selon les modalités définies aux articles 33 et 34 du RGPD. En cas de fuite de données confirmée, le notaire est tenu de notifier cette violation dans les meilleurs délais et, si possible, dans les 72 heures après en avoir pris connaissance. Sauf, bien entendu, si la violation n'est pas susceptible d'engendrer un risque pour les droits et libertés des personnes concernées. Lorsque le risque est élevé pour les droits et libertés, alors le notaire devra également notifier les personnes concernées de la violation de données à caractère personnel. Pour analyser ce risque élevé, il est nécessaire de prendre en compte le volume de données, la criticité des données, les catégories de personnes concernées.
Prenons le cas de la diffusion accidentelle de testaments sur Internet. Dans pareille situation, le notaire prendra contact avec l'autorité conformément à son obligation de notification de fuite de données. Il devra également avertir les personnes concernées par la fuite des données, car le risque d'atteinte à leurs droits et libertés est élevé.
Ladies and gentlemen, we move on to the last final section in our seminar. We will hear about the situation about GDPR in practice in Estonia and Latvia. The situation in Estonia will be covered by Katrin Sepp, assessor and advisor to the Chamber of Notaries of Estonia on legal matters. Madam Katrin Sepp, please join us. The floor is now yours.
Hello, can you hear me?
Yes, we can hear you.
Okay, thank you. Good afternoon and greetings from Tallinn. It has been a very interesting training day, but also quite intense. And as I am perfectly aware that I am one of the last speakers, my intervention is not going to be a long one. And I will just give you a brief overview of the Estonian notaries' practices when it comes to data protection in recent years. When I started preparing for today's presentation, I first reviewed what I had talked about at the data protection seminar in Vilnius in 2018. And what I discovered was that although the GDPR was new at the time, I was already quite optimistic then and believed that there was little cause for concern. First, Estonian data protection law, which existed before the regulation, was not significantly different from the GDPR rules. And secondly, our IT programs had already been designed to ensure data protection. And I'm happy to say that everything has indeed been working well in general, and it has been confirmed by the fact that although the number of complaints and other notifications filed with the Data Protection Inspectorate has been on rise in recent years, no complaints have been filed against notaries so far, and no information is known about the leakage of data from the notary offices. Nevertheless, some changes have taken place, and they mainly have to do with using IT systems and making inquiries to get data from registers. As many of you might know already, Estonian notaries use an IT system called e-notary as a tool for communicating with different registers, drawing up the authentic acts, archiving them, and so on. As the e-notary program is connected to at least 16 registers, getting the data from those is easy and could be made within a few clicks. But our goal in the past years has been to improve the system so that we could follow the principles of minimalism and purposefulness to the maximum extent. Thus, when a few years ago the notary or the notary's employee would get all the information stored in the population register about a person by clicking one button, now the person who makes the inquiry would have to choose what kind of information is needed for a specific transaction. Is it enough to just get the name, address, maybe information about the possible limitation of active legal capacity of the person, maybe the valid documents, or is it necessary to also get information on the person's relationships, and if so, which relationships? And I would say that this has been one of the most important developments regarding data protection. However, it is not only us who have been developing systems. The state has been doing the same. Estonian citizens have the possibility to keep an eye on who is accessing the data. This tool is called the data tracker, and it can be used via the citizen portal. In fact, the tool already existed before the GDPR, but the number of databases related to it has increased compared to 2018. For example, quite recently, citizens were given the opportunity to see who has accessed their real estate information in the land registry. As notaries are making at least 90,000 land registry inquiries per year, this change has, of course, affected us as well, as people are now asking the Chamber of Notaries why their information about the real estate has been accessed. The thing is that when using the data tracker, the register code of the Chamber of Notaries is displayed to the person. Thus, the person might not associate an inquiry with a certain notary's office. And if the question is sent to the Chamber can find out the notary office that made the inquiry. Then the Chamber replies to the person who made the request, saying that the inquiry was made in connection with a notarial act. And if necessary, the person can contact a certain notary office directly to specify the reason for making the inquiry. Like this, the use of data tracker is expected to lead to a considerable workload, both for the Chamber and the notaries themselves, answering the citizens' requests. More so, as the system is unable to distinguish in connection of which owner the inquiry was made if one land plot, for example, has several owners. What makes the situation a bit puzzling is that the general data in the land register has been public and should be public according to Estonian law. Furthermore, the law prescribes that a notary does not need to prove the legitimate interest to access the land registry files. Thus, the question has arose whether the use of the data tracker service is justified and necessary at all. Unfortunately, the state did not discuss the implementation of this tool with the stakeholders. And if the above was primarily about the use of databases, I would also like to say a few words about how the information flows between the notary's offices and clients these days. And to be honest, there is not much change here in the recent years, as the contracts are still sent by email and in the usual Word file format. Although the Estonian ID card actually makes it possible to encrypt files relatively easily. People just don't bother decrypting them and probably don't consider data leakage to be such a significant threat. In other words, the issue is not that the notary offices are not willing to encrypt the documents, but the clients just don't want it. From the beginning of 2020, the self-service portal is in use, whereby logging in with an ID card, the client can book an appointment at the notary's office and send and receive information related to a transaction, including reading and commenting on the draft project, and all in one secure channel, but its use is also rather small, and regular email is still preferred. Since the beginning of 2020, the remote authentication program is also in use, which allows notaries to authenticate acts over web without the need for participants to appear at the notary's office. For safety, but also for convenience, the program was entirely and specifically developed for Estonian notaries and integrated in our pre-existing e-notary system. It includes all the components we need for remote authentication, logging in with ID card, video call, the ability to record the call, sharing the document, and digitally signing the act. Using the remote authentication has raised the question of who should be allowed access to the video call. The involvement of, for example, brokers, lawyers, or other third parties. Some notaries see no problem if all parties agree. Others do not allow this at all. Some apparently do it selectively. But I guess this is a more general question when it comes to data protection and has not to do with remote authentication specifically. I mean, not all notaries allow such third parties to be present at the signing of a transaction if it physically takes place in a notary office either. Thus, I guess I can say that in recent years, some old concerns have appeared in a new format, but although the remote authentication is for Estonian notaries the biggest change and challenge in recent years, data protection-wise, it maybe has not made that much difference. To finish, I would switch from what has been done to the future to see what maybe could be done next in regard of data protection. And where I think we could improve our regulations and systems is when it comes to deleting the data after the period prescribed by law. Although many authenticated acts are, according to our regulations, archived and kept in paper archive forever, like last wills, contracts, powers of attorneys, the data used for preparing the acts, like emails, are stored electronically, and they should only be kept for a period of 10 years. Currently, the system does not delete the information automatically. It must be done manually, but I think automation of these systems is something that should be investigated. And as a conclusion, I can say that looking back to the past few years, the changes have not been too intense, thanks to the work that had been done before. However, we have not been sitting on our hands either. The systems have been constantly improved, and I guess we will just have to continue being at the same time both conservative when it comes to preserving the data and our clients' interests, and innovative when using the new tools and technology for doing it. But thank you. That's all from me at the moment.
Thank you very much. And now I would like to give the floor to Aigars Kaupe, and he'll talk about the situation in Latvia. Aigars Kaupe is a member of Latvian Sworn Notaries Council. He is a notary practicing in Riga. The floor is yours.
Dear colleagues, I'm always happy to be here in Vilnius. I'm happy to see that Vilnius is vibrant as always. It's developing, and you can see it just looking outside the window. And these days of uncertainty and restrictions, they make one recognize what a privilege it is and good feeling it is to be able to meet colleagues from Lithuania, from those from neighboring countries, and to exchange eyesight personally in presence. I even have a little lipstick mark on my mask, so it proves that we are really warm-hearted and nowhere humanity has disappeared during the pandemic. And going now to my presentation today, I would like to give you a little insight of applicable law in the field of data protection in Latvia concerning notaries, and also to point out some problems detected in the work of notaries in order to ensure correct application of data regulation. As you can see in this slide, data protection and the notariate might appear in three possible situations. The first and classical one, of course, is when the notary performs notarial duty, the notarial function. But then the other one is when the notary still does process data of the person, but it's not for the purposes of particular notarial function like certification or notarial act. These situations could be like consultations, drafting some draft of some application, a letter to the business partner, or application to some state institution. So there are many other activities notaries can do for the favor or for the interest of the client, but which is not regulated, particularly by law. So situation is a bit different from the first one. And then, of course, there is a council of, or the chamber of the notaries, which can be involved in data procession as well. And if we look at the legal scope of data protection for the notaries, then of course we should mention a general data protection regulation as a applicable, as the general rule of data protection, and that's European law applicable directly. And then, of course, there is notariate law, which regulates many procedural rules for notarial activities. But also there are various regulations of Cabinet of Ministers in particular fields of activities of the notary. Also, not only we have rules who regulate the activity of the notary, but of course also the chamber of the notary, because chamber of the notary can be also the person which works with the data of the client. And there are, for instance, specific regulations of how the Chamber of Notaries issue permission to a person to gather certain data from notaries' files. This can happen in the case if a person is not a participant of particular notarial act or certification, but the person still has provable and legal base for getting particular information or the document from the notary's files. And then there are also regulations for the Chamber of Notaries, how Chamber of the Notaries have to store data in those public registries which the holder or processor of data is Chamber of the Notaries itself. And let me mention another law, which I will go later and reflect to that in my presentation. This is anti-money laundering law, which does not provide any specific regulation on how to proceed with client due diligence, but it still affects the work of the notary in some other certain way. And let me show about the main legal act what regulates the notarial activities regarding data procession, and this is notariate law, and this prescribes that in the case if for the certification purposes or for the purposes of making a notarial act, person have to be identified, then certain list of data have to be obtained by the notary, verified by the notary, and at the end also entered into the certification text or notarial act. You can see there are 8, and some of them I highlighted in bold, and some of them I left unhighlighted. As you can see, all these data are collected, entered into the registry, and later on also shown in the notarial act, which is issued on hand to a client. As the consequence, not only the person itself or herself or himself or other participant of the same act or certification is able to see all data, but even other person to whom the act or certification will be later presented. All this process is legal, and no data procession is violated, since the notary only does what the law prescribes. Yet we have expressed concern ourselves in the Latvian Notarial Chamber already that these historically created requirements are no longer justified in the light and for the purpose of data protection. We see that certain data which are verified and entered into the registry of notarial activities should not be revealed in the certification text, which will be issued on hand for the client. And we have set the task for ourselves when the notariate law will be open for amendments. Notarial Chamber is ready to ask legislator to amend these stipulated particular requirements and probably eliminate these highlighted in a bold, not to be shown in the certification text anymore. And the data protection in the daily practice of the notary, I think, includes 3 basic principles which should be adopted in its notary's daily practice. We have heard already about them many times earlier today, so I will just highlight once more. So the notary shall never obtain the personal data to the extent exceeding necessity to discharge particular obligation. In order to ensure data protection in documents and its confidentiality, notaries should use only official electronic address specially designated for the notarial purposes, and would never use any home emails, no WhatsApp messages, no phone messages, and other tools for exchange with the documents. A notary shall not carry out data processing for a third party if so requested by the client just for the reasons of interest. Of course, if the person is interested to process her own data, then that's not the question. But the question would be that you have the client and he said, okay, I'm a creditor and there is a debtor, and can you check data of the debtor, for instance, in the registry of properties, whether or not I would be able to claim to the person, and should I have some security against my claim? So that request should be never accepted and never processed such kind of data. In theory, everything might sound quite clear, but when it comes to practice, one can find that some questions still arise. Let me name few. Here is the one situation described. A notary has been requested to develop a draft of the contract. While making the draft contract, notary performs the verification of personal data in the public register. The client eventually cancels the visit or just don't appear in the office. A year later, what should notary do, of course? Data are processed, but there is nothing entered into notarial registry because nothing has happened. So the notary, taking into account requirements of data protection, would delete or data unnecessary to be kept. And the law does not prescribe that notary keeps these data being sent to the notary. But a year later, notary is asked by the client to justify the data checks carried out. So the notary has deleted all the information. I believe notary will be not able to remember by heart. But notary still has an obligation to explain the client why these data have been processed. So this is open question. Just think about it. I'm not the data protection specialist. I'm not ready to give a correct answer, but sometimes it's more important to give the correct question and then to think about it afterwards. Yep. So then let me tell you about the other problematic situation that might occur in the practice of the notary. The notary must carry out all the verification of that personal data in the corresponding amount of data in the registers. But what would be consequences to the notary if it happened that notary checked data to the greater extent just because of the mistake? Should notary somehow act? Should notary inform the client or data inspectorate or chamber of the notaries about mistake what have been taken? And I think that here I would like to comment a little bit. I think that if it just happened by the accident, okay, you are still responsible. And if the client will ask from you about this data collection, then you should need to explain to the client. But otherwise, if you know that this data you collected, it's only you who saw it, and it never went out from the office, and no third parties were be able to get any information of that, what you have gathered, then probably no consequences to the client have been made. And then you shouldn't do any particular action. But that's also only my personal point of view. Then the other situation that would be more interesting to point out, and this relates that anti-money laundering requirement. The client asks notary to delete his personal data and requests no longer store data because the notarial certification has happened, and these data submitted to the notary for these purposes are no longer needed. Still, notary might think that he is obliged to keep these documents brought by the client in the archive. And that would happen if notary performed anti-money laundering requirements. So the client might think that it's not necessary because the AML law, it does not prescribe directly which documents a client should bring down to the notarial office in order to prove source of money, for instance. But the notary might have internal system of control of regarding anti-money laundering, and this system might presume that notary have to keep obtain these data and keep these data in registries. So that would be collision of interests of the client from point of view of data regulation, and also at the other end, interests or obligations of the notary based on AML law, but which are not prescribed by law. These are internal system of the notary, which prescribes a notary to act in certain way. I still think personally that notary still would follow its own internal system, and not comply with the request of the client in this situation. But the court will definitely be the one who says the final word in this situation. And overall conclusions of my today's presentation are here. There are 5. I would like to say that since the notariate law specifies all the activities of the notary, it's always necessary that only reasonable amount of data are processed. That's the basic principle for the notarial activity. Then probably no breach of requirements for data protection would take place. The second, it would not be reasonable for each separate notary to hire individual data protection specialist for his or her own office. However, it would be advisable for the Council of the Notaries to hire at least one data protection specialist or to use him as outsourcing specialist, but for all the notaries, for all the system what a notarial chamber has. And notary must be careful and attentive for not to process unreasonable large amounts of client data. And the Council of the Notaries has to ensure that the notary can obtain a certain amount of information in those registries that the notarial chamber holds. For instance, we have the registry of the last wills, we have the registry of the power of attorneys. So we always have to ensure that the notaries do not exceed by the accident and do not obtain too much information from that registry just by the accident. But notary will be able to look for the particular information for which notary is searching for. And we already have done such checkup of our internal systems in the Chamber of the Notary, and we should pay a great attention to that. And if notariate law or other special law does not provide for the notary's obligation to keep the client data, then in all these cases, these data must be deleted with no delay and in due time. And thank you very much. And I believe it was a hard and long day. And I'm sorry that I maybe exceeded a little bit my time left for the presentation. And we'll be happy to meet you everywhere in the presence, Vilnius or other city again. Thank you.
Dėkojame mūsų gerbiamam pranešėjui. Labai dėkojame taip pat, kad pas mus atvykote į Vilnių.
Ačiū for having come to Vilnius. Thank you very much. So, by information on personal data protection in Estonia and Latvia, we complete our seminar. We are grateful to all the speakers who have contributed to refreshing our memory on the history and the legal regulation on personal data protection. Thanks to them, we also have covered practical aspects that are relevant for the work of every notary. We equally thank all the participants of the seminar for having taken their time to study the conceptual and practical matters relating to personal data protection. We hope that the knowledge received during the seminar will be helpful. As Professor Štitilis has said, research and institutions working in data protection demonstrate that the human factor is among the key factors that lead to personal data breaches and cyber threats. Therefore, constant improvement of qualifications in the field of personal data protection and cybersecurity is an inevitable duty of every notary and notary's assistant. In hopes for the continuation of your consistent professional development on personal data protection, we look forward to your future participation in other trainings under the Training 4 project co-organized by the Lithuanian Chamber of Notaries and the Council of the Notariates of the European Union. Thank you very much once again to every participant, and see you again next time.